Well, my learned brothers and sisters, this is Advocate Devmorari talking to you from Ahmedabad city, Gujarat state, India. That is our Bharat. First of all, Diwali is very near. Happy and prosperous Diwali and happy and prosperous Vikram Samvat New Year. Today I've selected a very good topic. It consists of three parts. One is force, that is BNS section 128. Then comes criminal force, BNS section 129. Then comes assault, BNS section 130. BNS means there is a new law, Bharatiya Nyaya Sanhita 2023, that has replaced Indian Penal Code 1860. Now, first of all, I'll touch the topic force. First, I'll read out the law. BNS section 128 reads as like this. A person is said to use force to another if it causes motion, change of motion, or cessation of motion to that other, or if it causes to any substance such motion, or change of motion, or cessation of motion, as brings that substance into contact with any part of that other's body, or with anything which that other is wearing or carrying, or with anything so situated that such contact affects that other's sense of feeling, provided that the person causing the motion or change of motion or cessation of motion causes that motion, change of motion or cessation of motion in one of the following three ways, namely A, by his bodily power, B, by disposing any substance in such a manner that the motion or change or cessation of motion takes place without any further act on his part or on the part of any other person. By inducing, that is, by inducing any animal to move, to change its motion, or to cease to move. These are the ingredients of force under section 120 of BNS. Now, there is clear distinction between force defined in section 128 of BNS and criminal force defined in section 129. It is obvious from bare reading of section 128 and 129 of BNS, that is, it is using of force when a person brings substance in contact with any part of other's body. But the accused raises lathi to strike a person who had to flee to save himself. They were guilty of using force by their own bodily power. AR 1914, all 175. Where an accused went to the field of the complainant, stood in front of his plough, and unyoked the bullocks, the case fell within the definition of section 129 of and 130 of BNS. Inducing an animal to move, any amount to using force under BNS section 128, even though the word rescue in section 24 of the Cattle Trespass Act implies that use of force or violence. So these are the ingredients of force which we are supposed to know. Now next is criminal force. Now what is the difference between these two, force and criminal force? BNS section 129, and the same thing is discussed in IPC section 350. IPC means Indian Penal Code. Now it is replaced by BNS. It reads like this: whoever intentionally uses force to any person without that person's consent in order to the committing of any offense or intending by the use of such force to cause or knowing it to be likely that by the use of such force it will cause injury, fear, or annoyance to the person to whom the force is used is said to use criminal force to that other. Now, I'll give one illustration. He sets a dog to spring upon Jared without Jared's consent. Here, if he intends to cause injury, fear, or annoyance to Jared, he uses criminal force to Jared, even though his dog is doing that. Throwing stones at a house in which a person is living with the object of annoying him amounts to using criminal force. Hurling of abuses, Galidana, is neither a gesture nor a preparation to indicate use of criminal force. वो criminal force नहीं है, गाली देना हो. When accused persons snatch ballot papers from custody and possession of public servants and also tore them off, they could be held to have used criminal force. इलेक्शन का टाइम अगर बैलेट पेपर लूट लेते हैं, लेके जाते हैं, वहां तक तो आधा नहीं, मगर उसको फाड़ डालते हैं, then it is an offense, it is a criminal force. When act is in itself unlawful, consent can never be an available defense. गलत काम में कंसेंट की जरूरत नहीं होती है. The intention or knowledge of the person using force कैसे मालूम पड़ेगा? Must be gathered only from his conduct. He intentionally puts a woman's veil. Here he intentionally uses force to her. And if he does so without her consent, intending or knowing it to be likely that he may be thereby injure, frighten, or annoy her, he has used criminal force to her. There are three words: injure, ईजा पहुंचाने, frighten, घबराने का, and annoy her. ये तीन में से कोई भी. Now comes third, that is assault. BNS section 130. In Indian Penal Code, section is 351. Now, BNS section 130 reads as like this: whoever makes any gesture or any preparation intending or knowing it to be likely that such gesture or preparation will cause any person present to apprehend that he who makes that gesture or preparation is about to use criminal force to that person is said to commit an assault. Mere words do not amount to an assault, but the words which a person uses may give to his gestures or preparation such a meaning as when made those gestures or preparations amount to an assault. We have read the definition, now see the ingredients of the assault. A. That the accused made a gesture or preparation to use criminal force. B. That the same was made in the presence of the person in respect of whom the said gesture or preparation was made. C. That the accused knew or intended that such gesture, etc., would cause that other person to apprehend that criminal force would be used against him. And D, last, that such gesture or preparation did cause in the mind of the other person that the accused would use criminal force against him. Now I'll give illustration to understand this. He shakes his fist at Jared, intending, knowing it to be likely that he may thereby cause Jared to believe that he is about to strike Jared. Means he has committed an assault. Now I will give you a few citations. Mere alleging the assault without mentioning the facts continuing the assault does not bring the case within the ambit of assault as defined by BNS section 130. Next, where in the case of conviction of the accused under IPC section 323, now BNS section 115 subsection 2, for giving the complainant a lathi blow, it was pleaded that there are no medical evidence about the injury. There is no medical evidence, so IPC section 323 or BNS 115 subsection 2 is not applicable. This was the argument from the defense. But what was the view of court? It was held by the court that want of such evidence was unconsequential when there was a positive evidence that the complainant was assaulted by the accused and that the offense would still fall under section 130 BNS. Even though there is no medical evidence, the accused can be punished. But there shouldn't be cogent and positive evidence. Now, mere worldly altercation is not assault. That is not an assault. To point a loaded pistol at anyone is an assault under section 130. Citation is 1979 Sierra LJ 1275. The mere gesture of preparation with the intent or knowledge referred to in this section, that is 130 BNS, is itself an offense under this section. Citation is AR 1962, Alawa 22 in bracket 23. If two parties to strike one another, दो पार्टी है एक दूसरे को मारते हैं, and do so, it is an assault on both sides. Both sides can be punished. A mere obstruction or a mere surrounding a person, कोई आदमी जाता है उसको रोको, उसको घेरा घालो, it is not an assault. You are not doing anything. Now, what is the justifiable act? Pointing of a gun in self-defense is not an offense. Self-defense is there. Yeah, 1948, Nagpur 28, 48, Sierra LJ 252. That is alternative. Hope you have enjoyed this video. If you are new to our video, please subscribe it, share it, and like it. See you in the next video. Thank you very much for patient hearing and joining with us. Thank you, thank you, thank you.